during the process of this bill, and I commend this bill to the House.
Call Dennis O'Rourke.
Thank you, Mr Speaker. New Zealand First supports these three bills, and in doing so recognises that the privacy of information is one of the most important issues of today. Many people are rightfully worried about their information and that it should be used correctly by agencies of the state. Therefore, we need to be diligent to make sure that that is the case on their behalf. But New Zealand First supports the bill because we think it just goes far enough for those purposes. And the issue, of course, as expected, is the tension between the need for privacy protection on the one part and the need for government agencies to properly share information where that will improve the efficient operation of the public service. So it's the propriety of that which is one of the issues, and the second one, of course, is how will privacy of information be adequately protected. And while the bill does not go as far as the Law Commission recommended, and I respect the Green Party's position that they wouldn't support the bill unless it went that far, I think that, on balance, the bill has just gone far enough. The Privacy Commissioner having powers for compliance notices and audits, as the Green Party has suggested, and I think as the Labour Party wanted as well, would have been an improvement to the bill, but even without it, it's certainly a big improvement on the current situation. And so for those reasons, I think it should be supported. I'm glad to see that there are two really important aspects of the bill which do mitigate very much in favour of the protection of personal information. And the first is the right of a person to give notice, rather the requirement on agencies to give notice to people where their information is going to be shared. And the individual can take action to dispute information to ensure its accuracy. And provided agencies listen to what those who make use of this right have to say about the accuracy of information, I think that that's a very important right and should work quite well. The second provision, of course, and it's the big change introduced by this bill, are the requirements for information sharing agreements between agencies. Agreements must, under the Act, specify safeguards for the protection of personal information and provide for complaints to a government department. Also, only the necessary information for agencies for proper purposes is to be shared and no more. Agreements must not unreasonably impinge on the privacy of an individual, and agreements will be scrutinised by the Privacy Commissioner to ensure compliance with these important caveats. So those, I think, are the two really important aspects of the bill which we can rely upon for the protection of personal privacy, and in doing so, of course, we will be relying heavily upon the effectiveness of the Office of the Privacy Commissioner. And New Zealand First therefore supports the bill on the basis of that proper balance between the need for a robust sharing regime on the one hand and the protection of personal privacy on the other. And I note that the Privacy Commissioner will have three important roles. Firstly, in the oversight of the content of agreements and how they will operate. Secondly, the Commissioner's reporting functions to the Minister, who in certain circumstances must report to Parliament within 5 days. And thirdly, the Commissioner's consultation responsibilities in the formation of the information sharing agreements. However, agencies must always remember that they need to take seriously the specified actions to protect personal privacy and not pursue their own interests and not rely solely on the Privacy Commissioner for those purposes. That is why I think the requirements for agencies to consult on agreements is so important, and they must, of course, consult the Privacy Commissioner. But they must also consult any person or organisation representing the class of persons affected and anyone else the agencies think should be consulted. The Children's Commissioner is not specified, but may be still consulted under the provisions I have mentioned. The interests of children are a very significant issue, which must be well provided for, because those members of our community cannot be expected to look after their own interests and do need special treatment. It's therefore a disappointment that the government would not support my proposed amendment to add the Children's Commissioner as a mandatory consultee, because as the bill is, it effectively means that it will be the agencies which will decide if there is a need to consult the Children's Commissioner, whereas under my amendment it would have been compulsory to consult the Children's Commissioner, and the Children's Commissioner could then have decided whether a consultation was needed. So it's a disappointment that I think very sensible amendment, which would have been harmless, would not have imposed greatly on the agencies concerned, was not included in the bill. And it's disappointing also that the government simply doesn't listen to good ideas and doesn't consider them properly. On some occasions, ministers have said in this House of me that I didn't go and talk to them about it. Well, what's the point when they simply don't listen? And if they're not going to listen, then I'm not going to bother to waste my time with them. So if they genuinely do want other people in the House to contribute constructively, there is an obligation on ministers to genuinely listen to what is said and, where appropriate, to take action. The minister did not do so in this case, clearly should have done so, and I think stands indicted for simply not listening. And therefore, what we have is a situation where there is a defect in the bill which could have been completely avoided simply by making the Children's Commissioner a mandatory consultee. However, that wasn't done. Nevertheless, even with all the various defects in the bill, and I concur with many of those that other speakers have mentioned, and I too would have liked to have seen some more action in the enforcement area. Nevertheless, with all those defects, warts and all, this bill is still a considerable improvement on the current situation, and for those reasons, Mr. Speaker, New Zealand First will support the bill.
I call Jamie Lee Ross.
Mr. Speaker, I only wish to speak very briefly.